So as we mentioned in the first video, we're going to be talking about the individual aspects of a contract, what makes a contract valid. Things like an agreement, which requires an offer and an acceptance, things like consideration, things like intention to create legal relations. And we're going to begin by looking at agreement, and more specifically, we're going to be looking at the offer. Okay, I'm going to spend the next few videos looking specifically at the law relating to the offer. We're going to do a couple of cases in this video, and then we're going to get quite case heavy in the next few. So, in terms of a general introduction over here, so a general introduction over here, an offer can be described as a willingness to contract on specific terms. Okay, and this is made with the intention that it will become binding as soon as accepted. Okay, now this is important. So we have got a willingness to contract when it comes to specific terms. These are the terms of the contract, okay, that are being offered, and the intention being that when this offer has been accepted, we have an agreement that is in place, okay? And if there is consideration and if there is intention to create legal relations, then we have ourselves a contract. In just terms of some kind of nomenclature or terminology that we want to be looking at here, the party who makes an offer is known as an offerer, and the party to whom the offer is addressed to is known as the offeree. So when we talk about these are the two things, just to make sure everybody is clear on that. So in determining an offer, the general practice is that the courts will adopt what we call an objective test, okay, as to the offerer's intention. Okay, and this objective test looks a little bit like this, and they basically would say, if a reasonable person were to believe that the offer had the intention to be binding, then this could be sufficient as a valid offer. Okay, so there are a number of examples where an offer is made unintentionally. However, mistakenly, an offer is made. But the problem with this is when we apply the objective test, if the offeree, the person who is receiving the offer, reasonably believes that this was a binding, this had the intention of being a binding offer, then it could still be sufficient to the creation of a contract between the two parties. And this can be seen in two cases that I've got here, okay, and I'll list a couple more down below if anybody wants any more, and I'll also list links to these cases specifically. So we've got Moran and University College Salford in 1994. This is a case where the defendant was a university, okay, and they had offered Moran a place to study physiotherapy for the next academic year, okay. So these are the important facts of the case. So we have an offer to study physiotherapy made to Moran, who is the offeree, okay, to study physiotherapy. The offer was then accepted by Moran, okay, so we have the existence, we have an agreement in place. So we have an agreement in place. However, in reality, okay, this offer was only a clerical error, okay, and this is something that was only revealed to Moran in September, okay, and under the impression that an offer was made, a legitimate offer was made. Moran had quit their job, okay, in London, and accommodation was made and arrangements like that. All of these things that a reasonable person would do in the event of a legitimate offer being made. Okay, so these are what a reasonable response. A reasonable response to a legitimate offer. To a legitimate offer. Now, applying the objective test, we would say, okay, in this situation, would a reasonable person have the expressed understanding that an offer, a legitimate offer, had been granted? The Court of Appeal held that a contract had taken place. Okay, a contract had existed. Okay, a contract existed between the two parties. And this was, oh, that's terrible handwriting, I'm sorry. This was because Moran was under the reasonable impression that an offer was made. Okay, and Moran was entitled to relief in the form of compensation, because the university had effectively entered into a contract, but the terms of the contract were not fulfilled by the university because of this clerical error. In reality, an offer was not made. One point that should be noted about this case is that a contract would not have existed if it was reasonable that Moran had known about the error. What I'm suggesting here is, if a reasonable person would have been under the impression that the offer was a mistake, then a contract would not have existed, because it wouldn't have met the requirements for this objective test. And so in this situation, because an offer was made, and the fact that it was a clerical error was only revealed in September, okay, and it was sufficient for a reasonable person to believe that an offer would have existed, and so therefore a contract had existed. There's more reading on this in the description as well as the case itself. A second example of in application of the objective test, we have OT Africa Line Limited and Vickers PLC from 1996, and in this case we have a very interesting set of facts. A solicitor had mistakenly offered to settle a claim for £150,000 rather than the offer that was instructed by the client. Okay, so this is instructed by the client. Okay, and the offer was in reality $155,000. So not only was the price wrong, the specific number, but also the exchange rate was wrong. And again, according to if we apply this objective test, if a reasonable person was to believe that this was a genuine offer, then the contract was formed. Okay, and in this case, this is the case, okay, regardless of the state of mind of the offerer. So this is another example of applying the objective test, and we find that in a reasonable situation, a reasonable person would believe that this was a genuine offer, and so therefore a contract should exist between the two parties. So getting an understanding of the offer is very important. Okay, and it's important that we also distinguish between what we call an offer and an invitation to treat, and we're going to use that to look up and sort of develop, our understanding of the first aspect of contract law, which is the aspect of agreement, and we're going to do that in the next video.